Hello everyone, myself Abhishek Sharma. I am an assistant professor of law from ICFAI Law School, Hyderabad. The topic for today's lecture is the interrelationship between non-fungible tokens and copyright law and analysis. Why I have chosen this topic? Because many people now have many misconceptions when it comes to non-fungible tokens and NFT. So I will deal with various issues and implications that copyright law has over the non-fungible tokens. Coming to the introduction, when it comes to intellectual property rights, not everything that glitters is gold. This statement by Dr. Benjamin Mitraken fits aptly when we talk about non-fungible tokens. The rise of non-fungible tokens have changed the digital asset industry completely. You must have heard about CryptoKitties, CryptoPunks, which are being sold by Nike. Then every day, the first 5,000 day, it is sold by the Christie auction house. And many tweets are also being sold over the internet. For example, the ex-CEO of Twitter, Jack Dorsey, has also sold his NFT for millions of dollars. So now the question comes, what are NFTs and why are they being sold for millions of dollars? So first, to understand non-fungible tokens, we need to understand that what is blockchain technology. Because non-fungible tokens are being stored over the blockchain network, so all the qualities and the essential elements that are present in blockchain network is also present in non-fungible tokens. So if we define blockchain, a blockchain is a cryptographic, distributed and decentralized ledger which keeps permanent and public record of transaction by appending information in an immutable record. So as you all can see, there are basically 3 to 4 technologies which merge together and form the blockchain technology. So firstly is cryptography. Basically when you use public and private key for someone to send a document so that he can only access that particular document or the object, that is cryptography. Also, it is said that the blockchain works on the distributed and decentralized ledger. So all the data which are being present over the blockchain network is not stored at a centralized level. It is distributed over the various nodes, and all the nodes or the computer have the access in relation to that blockchain data. And also the data which is present in that blockchain network is immutable. So all these essential qualities are also present in non-fungible tokens. Now, one of the most indicative use of blockchain technology is tokenization of assets. What do we mean by tokenization of assets? So when we convert a particular tangible assets from real life into a digital value, that is tokenization. Now there are basically 2 types of tokens, fungible tokens and non-fungible tokens. ERC-20 sets out a standard for fungible tokens, while ERC-721 sets out the standard for non-fungible token. Now, what is the difference between fungible tokens and non-fungible token? For fungible token, the real life example that I can give you is a 10 rupee of coin. Suppose I have a 10 rupees coin and you also have a 10 rupees coin. If we interchange both the 10 rupees coin with each other, we are not getting affected by it because the monetary value of both the coins is the same. So these are identical. So fungible tokens are basically identical in nature. So for example, all the cryptocurrencies like Bitcoin, Dogecoins, all these are the example of fungible tokens. While in case of non-fungible tokens, all the tokens which are non-fungible tokens are unique in itself. So they are not similar or identical with each other. Now, when it comes to non-fungible tokens, one of the misconceptions attached with the NFT is that it is a digital version of the underlying assets. Now, NFT is not the digital version of the underlying assets, rather it is the metadata which is uploaded on the blockchain network. So when we have to make a NFT, you need to have a tangible object, then you will create a digital copy of the tangible object, and then by using that digital copy, you would write some codes and then you would upload that codes on the blockchain network. That codes or metadata of that underlying asset is exactly the NFT rather than the digital copy. Now in NFT, there are basically 2 elements which are present. First of all, it is the token ID and second one is the contract address. Now the combination of these 2 elements, the token ID and contract address, is the thing which makes NFT unique with each other. Now as you all can see in the slides, on the left hand side we have an image of a Hero Honda bat, and on the right hand side you can see some alphanumeric elements and numbers. So in the left hand side, this bat belongs to Yuvraj Singh. He sold this bat or the image of this bat as an NFT. Now, when he sold this bet as an NFT, it is not this digital copy on the left hand side which is being sold by Yuvraj Singh. Rather, on the right hand side, as you can see, the codes are written. This is the right hand side image is known as non-fungible token. Now, in the non-fungible tokens, as you can see, there are many elements that are present, like symbol, image, animation URL, royalty amount, copyright transfer, address, and token address. Now you can see that in token address and token ID, these two numbers are the numbers which make a non-fungible token unique. Also, there are many elements that are present. Also, the URL of that digital copy is also present over the NFT. Like that, there are many. So, generally, when a purchaser buys an NFT, they are not buying the digital copy of the asset, but just purchasing the metadata which exists on the blockchain that I showed in your last slide. Now, some people have therefore compared NFT to a signed copy of a work. Now, this is also somewhat inaccurate, as the NFT is not the digital copy in itself, rather it is more like a signed receipt of the work which will authenticate that particular digital copy. Now, to define NFT, NFTs are virtual assets in the form of metadata which are added on a blockchain and are cryptographically signed, which make them distinctive from other copies. So this is the definition of NFT. Now, further, if we define NFT, there are two classes of NFTs. Firstly, off-chain NFT, and secondly, on-chain NFT. Now, what do we mean by off-chain NFT? When our digital copy is there and we write some codes and upload the codes over the blockchain network, that is an example of off-chain NFT. In off-chain NFT, we are not uploading the digital copy of the underlying asset along with the codes. Only the codes or the metadata of the underlying assets is being uploaded on the blockchain network. While in case of on-chain NFT, the work in entirety is uploaded on the blockchain network. So both the codes or the metadata of the underlying assets along with the digital copy is also added on the blockchain network. Now, coming to the analysis of issues and concerns arising out of non-fungible tokens and IPR. Now, I have already been dealing with the analyze issues and concerns arising out of NFT and copyright law. So, the first issue that arises is whether NFT would confer copyright protection to the buyer of an NFT. Now, to answer this question, I will take help of an example. Suppose you buy a book from me. I have the copyright over that book because I am the author, and I sold that book to you along with the certificate of authenticity. Now, whether this certificate of authenticity being given to you would also confer the copyright protection? No. You would only be having the ownership over the book and the certificate. You won't be having the ownership of the copyright. Now, second question that comes to our mind is, can copyright protection could be provided to NFT? Now, when copyright protection has to be provided to an object or a work, three essential elements has to be fulfilled. Firstly, it should be original. Secondly, it should come under Section 13 of the Copyright Act, which talks about the various subject matter over which the copyright protection has been granted. And thirdly, the fixation of work. So, firstly, original, yes, as non-fungible tokens are unique in itself. So, when one non-fungible token is made, it would be unique with other work. Also, originality in copyright law means something which is created by yourself independently and also not copied from other works. So, non-fungible token as a basic characteristic is original in itself. Secondly, can they come under any of the work which are being given under Section 13 of the Copyright Act? Now, if we see the language of Section 13 of the Copyright Act, it states that works in which copyright subsist. So, these are original, literary, dramatic, musical and artistic work, cinematographic film and sound recording. Further, if we see the definition of literary work under the Copyright Act, it has been defined under Section 2(o) of the Copyright Act, which state that literary work includes computer programs, table and compilation, including computer database. Now, this is an inclusive definition, but while literary work under the copyright means that's something which is written. Now, if we further go to the definition of computer program as defined under the Copyright Act, it is given under Section 2FFC of the Copyright Act, which define computer programs as a set of instructions expressed in words, codes, schemes, or in any other form, including a machine-readable medium, capable of causing a computer to perform a particular task or achieve a particular result. So as you all can see in the definition of computer program, the words, the codes which are being given by the author to the computer to create a work are also being protected as a literary work. So even NFT are also codes or metadata which are existing on blockchain. So we can consider NFT as a literary work under the Copyright Act, and thereby copyright protection could be granted to NFT. Also, fixation is being done as it is stored over the network, blockchain network, and as the data which is being stored on over the blockchain network are immutable and are not destroyed. So they are permanent in nature. So that's why all the three essential requirement for copyright protection is there in case of non-fungible tokens. So non-fungible token should be provided copyright protection when all these three elements are present. Now, another issue is whether the sale of NFT would trigger the royalty right provision under the copyright law. Now, under the copyright law, there is this provision which talk about the royalty rights or the resale share right. But before explaining the resale share right, when the NFT is being sold, we need to understand what are the general terms and conditions when an NFT is sold to a buyer. The general terms are only limited personal non-commercial use and resale rights in the NFT are granted, and you have no right to license, commercially exploit, reproduce, distribute, prepare derivative works, publicly perform or publicly display the NFT or the music or the artwork therein. All copyright and other rights are reserved and not granted. So generally only two rights are being granted to the buyer of an NFT. What are those? Firstly, the personal non-commercial use, and secondly, the resale right. If you got the NFT from someone, you can use that for personal purpose, and secondly, you can sell that NFT to the third person. So these two rights are being given to the buyers of an NFT. Now, therefore, artist generally keeps all the resale shared royalty rights along with themselves, which are also known as droit de suite. Now, what is this provision under Copyright Act? There is this provision, section 53A of the Copyright Act, which state that in the case of resale for a price exceeding 10,000 rupees of the original copy of the painting, sculpture or drawing, or of the original manuscript of the literary or dramatic work or musical work, the author of such work, if he was the first owner of rights under section 17, or his legal heirs, shall, notwithstanding any assignment of copyright in such work, have a right to share in the resale price of such original copy or manuscript in accordance with the provision of this section. So as you all can see, two essential requirements has to be fulfilled for the author of the NFT or the minter of the NFT to get the resale share rights. What are those? Firstly, the price at which the NFT is being sold should exceed 10,000 rupees, and secondly, the NFT when it is being sold should be the original copy or the original manuscript of the work. Now the question comes, can artists claim resale share right over NFT? Now it depends. Now in case of off-chain NFT, only the metadata or the codes are being transferred. So there is no case of getting the resale share right. But in case of on-chain NFT, the codes along with the digital copy is added on the blockchain network. Now all their digital copy is also being sold along with the codes in case of on-chain NFT. Now if the digital copy is the original copy or the original literary work, in that case yes, resale share right can be provided, otherwise not. Now the last issue that depends upon the NFT and the Copyright Act is whether unauthorized minting of a work to NFT by a person who is not the copyright owner of the underlying asset would be considered as a copyright infringement. Suppose I have a photograph over which I have the copyright protection because I clicked it. Now if over that copyright protection, if you click or you make an NFT of that particular digital copy, would it be copyright infringement or not? So NFT, as I explained, are mostly metadata which represent the underlying asset. So is this act of minting a work by writing codes or metadata can amounts to infringement? Now if we see the definition of infringement under the Copyright Act, section 51 of the Copyright Act talks about the copyright infringement. It states that if a person does anything for which the exclusive right is subsists with any other person without the license by the copyright holder or the registrar of copyright. Now, what are these rights which are being talked about? It is given under section 14 of the Copyright Act, which talk about the exclusive and economic rights of the author of the work. It defines that the exclusive rights of the authors are the right to reproduce the work, the right to issue copies of the work, the right to give on rent or sale, the right to perform the work in public or communicate the work to the public, the right to make adaptation, derivation and translation of the work, the right to communicate the work to the public. Now, not all these rights are applicable in case of NFTs, thus only the aspect of the right to reproduce the work, the right to make adaptation and the right to communicate the work to the public would be discussed in this lecture. Now, the issue is whether minting of a work into an NFT would be considered as a reproduction of the work. Now, it depends upon the type of NFT. In the case of on-chain NFT, the answer to the question is relatively easy as compared to off-chain NFT. Why? When we create a on-chain NFT, the digital copy is also added on the blockchain network. So to make an on-chain NFT, the essential requirement is that you need to reproduce the particular underlying asset into a digital copy. Only then you would be able to create the on-chain NFT. So there is the clear case of reproduction of the work, and thereby in case of on-chain NFT, when some unauthorized minting of the work has been done, in that case, yes, it is a copyright infringement. But what about the case of off-chain NFT? Now, in case of off-chain NFT, only the data or the metadata of that underlying assets is being stored on the blockchain network and is being transferred to the third person, who is the buyer of the NFT. Now, can we call the codes or the metadata which is being created by the underlying assets as a reproduction of the work? It is not. Now, whether an NFT can be considered as an adaptation of the work. Now, if we see the definition of adaptation under the Copyright Act is defined under section 2A of the Copyright Act, which state that adaptation means in relation to any work, any use of such work involving its rearrangement or alteration. Also, there are many cases in respect to adaptation, like Bridget Foley and Hunter vs. Elliott, in which it was held that the defendant has not infringed the copyright in the knitting guide by knitting a garment by following the instruction present over the knitting guide. Also, there is a similar case where John Whitworth of the British court has held that you do not infringe copyright in the recipe by making a cake. This was held in the case of J&S Davis Holding Limited versus Right Health Group. Now, even in case of NFT, you use the digital copy. Whether that digital copy is the NFT? No. In case of on-chain NFT is obviously the infringement that I already discussed in case of reproduction. But what about in case of off-chain NFT? In case of off-chain NFT, you are only transferring the metadata. You are not manipulating any kind of thing in case of the digital copy. So here the adaptation is not there in case of off-chain NFT. Now, the third issue is in case of off-chain NFT, whether minting of a work into an off-chain NFT could be considered as a communication to the public. Now, in regard to India, the jurisprudence in regard to NFT and linking and communication of the work to the public has not been yet developed. So, I will be discussing some of the European states cases. First one is Dramatico Entertainment Limited and others versus British Sky Broadcasting Limited and others of 2012, where it was held that the act of by the file sharing platform like torrent would be communication to the public, as copies of the sound recording are made available to users who have not purchased from an authorized source. So when the links are also being there in a URL or a website or web page, in that case also it would be considered as a communication to the public. Also, in case of Neil Swenson and other versus Retriever Sivers AB, it was held by the court that hyperlinking to the copyright content which is freely available to the general public on other websites would not amount to copyright infringement. In this case, the court considered the public in communication to the public to means new public. Now, if we talk about the Indian context, the communication of the work to the public has been defined under Section 2FF of the Copyright Act. It states that making any work or performance available for being heard or seen or otherwise enjoyed by the public directly or by means of any display or diffusion other than by issuing physical copies of it, whether simultaneously or at places and times chosen individually, regardless of whether any member of the public actually sees, hears or otherwise enjoys the work or performance so made available. So in the Copyright Act, under the definition of communication of the work to the public, there is an essential requirement that even though the work is not being seen or heard by a third person, even in that case it could be considered as a communication of the work to the public, provided it is available for being seen or heard. Now in case of NFT, when I discussed the various elements or the image of the NFT, you must have seen that there was a URL of the digital copy which is also attached in case of non-fungible token. Now can we call that link to the digital copy as a communication of the work to the public because it is available? Now arguments are being made from both the sides. From the minters of the NFT, they are saying that no, it is not copyright infringement, and from the artist over the work, over whose work the NFT is being created, they are saying yes, this is copyright infringement. So arguments which are being made by the minters of NFT are saying that both the links are different. The link which are being present over the normal websites are different, and the link which is being present in the NFT is usually different. It is usually the metadata or the codes which are in the form of URLs. And secondly, the threshold for considering something as public is also not met in case of NFT, because as the link which are being present over the NFT is very difficult to access. Only very tech savvy people can access these links. So whether both these things can be considered as communication of the work to the public, now it would depend upon the courts how they would be interpreting this particular provision. Now let us discuss the liability of secondary infringers. Now as you all can see, when NFT is being sold, it is generally being sold at marketplace of the websites or in auction houses. So when a listing has been done of a particular NFT, what are the things which are being there? Firstly, thumbnail of the underlying asset is usually present over the listing. Also the link to the digital assets and smart contract link address are being there. Now, though the act of hosting links which direct to the infringing copies, along with this act of hosting thumbnail on the list page will be communication to the public. So generally the liability part in relation to the infringement of the NFT is with the secondary infringers or the marketplace rather than the primary people who are minting the work into an NFT. Now also these secondary infringers or the marketplace or intermediary can take the defense under the IT Act under section 79, which talks about the intermediary liability. It said that notwithstanding anything contained in any law for the time being in force, but subject to the provision of subsection 2 and 3, an intermediary shall not be liable for any third-party information, data or communication link made available or hosted by him. So under subsection 2 and 3, the due diligence or safe harbor principle is being given. So if they are taking the defense under the subsection 2 and 3 of the section 79 of the IT Act, in that case, they are extinguishing their liability, otherwise they would be considered as secondary infringers. Now in conclusion, I would have to say that the current rise of NFT is due to the fact that NFT provide ownership, proof of ownership, authenticity and transferability as all the essential requirements of the blockchain technology or the features of blockchain technology are also present over the NFT because it is stored over the blockchain network. NFT presents many new opportunities and threats for IP right holder in the area of intellectual property right. Not only for copyright law, even in case of trademark and patent, NFT provide many opportunities and threats. Also with the rise of NFT, there would be a lot of interaction between the NFTs and IP right holder. As the gateway of the NFT and NFT space, the NFT marketplace or the websites or the auction houses are filtering all the listings which can be a potential infringement, but nonetheless there are cases of copyright infringement in case of NFT now as well. So in copyright law, as there is a clear infringement in case of on-chain NFT, the most complicated and discussed issue would be whether minting of an off-chain NFT would amount to copyright infringement. At least from the perspective of the Indian jurisdiction, a strong argument could be made against the potential infringement for an unauthorized minting of an off-chain NFT. In case of on-chain NFT, there is a clear case of copyright infringement. Also in case of off-chain NFT, a closer analysis need to be done with respect to communication to the public while linking the NFT with the digital copy of the work. That would be done by the judiciary. Now, further, it is seen that with the time, more practical uses of NFT are emerging. So, there is a need for awareness and education among the artists in respect of the area surrounding NFT, as the amount of misinformation and the misconception regarding NFT is astonishing. Now, there are still many different questions which are not been discussed in the present lecture, which are open with regard to IPR and NFT, such as the first seal doctrine under the Copyright Act, the exhaustion principle, which offer a really interesting approach that needs to be explored in the future. Also, the interface between NFT and artificial intelligence generated works are also increasing with time. Similarly, this interrelationship between NFT and IPR theory need to be studied further. With respect to growing development in the field of NFT space, as under this lecture, the author has just scratched the surface of the vast topic. Thank you. That's all for the today's lecture.